9 minutes before the hour now, and police officers should have the authority to secretly place a GPS tracking device on any suspect's vehicle without a warrant. That's according to a new rule by the Ninth Circuit Court of Appeals in Northern California. The decision stems from a case in Oregon, a case in which DEA agents attached a GPS device to a suspected marijuana grower's truck. Investigators then used that data to find the pot and arrest the guy. But the suspect appealed his conviction, claiming the cops violated his right to privacy. The court did not agree. With us now, the criminal defense attorney Mark Eiglarsh and the former prosecutor Steve Razor. Good to see you both. Thank you.
Good to see you, Shep.
Steve, is it fair? I mean, the police get to make these decisions instead of the court?
Well, I don't know about fairness. I mean, I'll start with this, Shep. I'm going to say that nobody likes the idea of police officers sneaking around in somebody's driveway. If anybody doesn't like the law as it currently exists, the way to go is through Congress or the state legislature, because the fact of the matter is that the law is clear on this point. There is currently right now a split between the California federal court, that circuit court, and D.C. Now, in D.C., is bringing up another issue here beyond that, which says, please, we don't want people walking around in our driveways. The other issue is we don't want somebody tracking us over a long period of time with these GPS devices. So this is a first-case scenario for this particular aspect of it. Before this, in the 1980s, the Supreme Court had ruled that it was permissible for the police to put a beeper, a tracking device, on a vehicle and follow it from a mile away. This goes one step further with the GPS device.
Mark, does it go too far?
Absolutely. I think it's downright creepy, Shep. Let's look at the hypothetical. Forget about the drug dealers. Yeah, they should be caught. They should go to jail. It's good for my business and Steve's. Let's talk about how it could affect us. Anybody could find a law enforcement officer in the middle of the night in their own driveway wearing all black, so the neighbor comes out. He has no idea as he confronts this guy with his shotgun who it is. And while law enforcement is standing in your driveway, where they have a right to be because you have no reasonable expectation of privacy in your own driveway, he can kind of look into your window, and anything in plain view now becomes something that they can use against you. I don't like it.
See, Shep, if I can here, I want to point out to Mark that the situation here is allowing the police to do through technology what they could otherwise do. Because what this GPS device allows them to do is not to search the vehicle, not to search their house, but to follow the vehicle once the vehicle leaves the house.
I understand that, Steve.
If this was a device that allowed them to look into the vehicle or allow them to look into the house, then it would be impermissible. However, the police they can follow a car from somebody's house. Yes.
First of all, if somebody is in a public place, that's one thing. This ruling allows law enforcement officers to step into your castle. The curtilage in front of your house is your castle, and they can go on there with no reason at all, no judicial oversight. They don't have to go up to a judge and say, by the way, I'm doing this for no reason because I like Shepard Smith and I just want to follow him because he seems creepy. Yeah. They're allowed to do that now, and I have a problem with that.
But here's the thing, though. This has been the case for quite a while now. The Supreme Court has gone into this already and stated that the driveway is a different scenario. In People v. Dunn in 1987, the Supreme Court ruled on 4 different categories that would judge whether or not the police intrusion was unreasonable or not. And one of those things was, what's the common use of a driveway? The common use of a driveway is a delivery person come in to drop off a package. The police or anybody can come in and serve a summons. That is not protected. Now, what I'm saying to you, Mark, is I agree with what you're saying.
What,
however,
that I'm creepy?
I'm sorry? That's creepy. Yeah, absolutely. I do agree with you. And what I'm saying is, let's go to the legislature and let's change the law. Right now, it is permissible under the law, and we need to judge the law, not whether we like it or not.
All right, there you go.
You know who's you know who's not upset at all? Those who make gates around houses, because if you put a gate around there and no trespass, then you have a reasonable expectation of privacy.
More jobs. Thanks, guys. Appreciate it.
Thank you, Chef.